All right. John, thank you.
Good evening.
Good evening.
I'm Gloria Reed, co-president of the League of Women Voters of the Rochester metropolitan area. The League is a nonpartisan political organization which encourages the informed and active participation of citizens in government and influences public policy through education and advocacy. The League is not limited to women. Men can join in making democracy work as well. The League is co-sponsoring tonight's forum with the Social Justice Council of the First Unitarian Church of Rochester. On behalf of all the members of the Rochester Metropolitan League of Women Voters, I'd like to welcome you to our November forum, Money in Politics, is Democracy for Sale? We are proud to present this panel discussion on this important issue, and we are especially pleased to be able to offer a question and answer segment following the presentations. This will be a recorded event tonight, so if you're going to ask a question, please speak up when asking your question. Our panelists are Sam Fedeli. Mr. Fedeli, since retiring as an educator, has focused his energies and analytic skills on diminishing the corrupting influence of money on our democratic processes. He has been a committed activist in the social justice movement locally and at the state level. Roy Gutterman. Professor Gutterman is director of the Newhouse School's Tully Center for Free Speech and is an expert on communications law and the First Amendment. He is a published author of many articles on this topic and related fields. Scott Forsyth. Mr. Forsyth is a Rochester attorney in private practice who frequently speaks on the Bill of Rights and political issues of the day. He has aided many not-for-profit organizations in this community. And now it's my pleasure to introduce our distinguished moderator this evening, our longtime League member and dedicated volunteer, Dorothy Borges.
Thank you, Gloria. Tonight's presentation will include a 15-minute presentation by each of our three panelists. We have allowed approximately 45 minutes then for this section of the program. From 8 till 8:30, we will take questions from the audience. As Gloria said, since this presentation is being televised, please speak up with your questions when you're called upon. If you have more than one question you'd like to ask, please allow other audience members to voice their questions before you present a second or third question. Direct your question, if you want, to a specific panelist. Otherwise, your question will be answered by the next presenter in line from your left to right. The answers to the questions will be limited to 2 to 3 minutes, depending on the time that we have left in the program once the panelists have presented their talks. So, are there any questions before I start? Fine. Then we will begin with Mr. Roy Gutterman. Mr. Gutterman.
Thank you, Dorothy. Thank you, League of Women Voters, one of my favorite organizations. I think you do a lot of really great work for civics, and especially in election seasons. Gloria, thank you. Kathy, wherever you are, thank you for inviting me. My background is really with the First Amendment. I'm a former newspaper reporter. I am a former lawyer, and now I teach First Amendment full-time. So my theory is more speech is good speech, even if it's not speech that we really like. However, I'm talking tonight about the Citizens United case, which is probably one of the more controversial Supreme Court decisions to come down just about anybody's memory. Going back, I read a lot of Supreme Court cases. You can go back a couple hundred years, and this is probably going to be one that is one of the more controversial. I think history is going to show how controversial this case really is in many different ways. Just to summarize the two major holdings that this case decided. One is the role of corporations and the First Amendment rights of corporations, and the equation of money with First Amendment rights. We're going to come back to that in a little bit, because I would like to start with just a brief discussion about the First Amendment in general. Okay? Now, I stopped reading the other amendments after the first, so I don't know about all the other ones. But the first is enough for me. All right, what does the First Amendment protect? It protects freedom of speech, freedom of religion, freedom of press,
Right of assembly.
right of assembly, and the freedom to petition government for redress of grievances. Some scholars consider that 6 rights, some consider it 5 because the religion clause is 2 different sections. So in some ways, we are exhibiting and exercising First Amendment rights simply by being here in a house of worship to talk about politics and probably complain about politics too. So those are our basic rights. And we all express them and exhibit them a number of different ways. At its basic level, the First Amendment was adopted as an anti-censorship protection to protect this fledgling country 200 years ago, 200 plus years ago, from government censorship. And really that's how it stayed for a good 100 years or so, right? The preface, Congress shall make no law. Well, that means Congress, which is really a synonym for government, can't make any laws that would infringe on these rights. Okay, so it was started as an anti-censorship protection. And in many ways it still is. And there are some justices and judges who really look at First Amendment cases through this lens of, is this going to be a censorship issue? But I would like to quote one of my favorite justices, Justice Brandeis, who famously wrote in a concurring opinion almost 100 years ago, those who want our independence believe that public discussion is a political duty. Public discussion is a political duty. This is a concept that's really infused much of American public life, and it still does. And cases over the next 100 plus years have really gotten to the point on that, and really weigh what we're going to allow our society to do in the lens of a political question. So when we look at this, and we look at this effect on speech, particularly the First Amendment, we see how many of our cases are really challenging how far we're going to go with government regulation. How far is a regulation going to go to become an issue of censorship? And these are questions that have come up in cases involving press and pure speech and commercial speech and advertising, and now political speech. But again, back to how the First Amendment has played out in some really difficult cases. Questions on things like reporting or disseminating information about military operations or contemporaneous military operations. There's a difference. You can report about what happened, but if you're going to try to report about what's going to happen, well, maybe there's going to be a line there. A line where there might be some legitimate censorship without offending the First Amendment. Things like defamation, saying something false that harms somebody's reputation. Well, that might be an area where we might not want to have a totally unrestricted area there. So we have some compromises, especially when it comes to public officials. So public officials have a different standard than a regular person when it comes to proving a false statement of fact about them that harms their reputation. I could spend an hour just talking about defamation, but I won't. Even speech that may incite a riot has some limitation, and it also has some flexibility. So we're really dealing with a whole range of potential speech and how far we're going to go to rein that in. How far the government is going to go. And when I say the government, that could be anything from the federal government to locality, to a school board, to a town hall, a town council. Government is really an expansive area now. So even beyond the original Congress shall make no law, we really mean government shall make no law. Right? However, or but, or whatever you want to say, there's always going to be some potential to rein this in, some potential for limitations. And that's where we really get into how far we're going to go with these limitations. And that's where the issue of a compelling state interest comes in. So we'll have all this free speech out there unless it falls into one of the narrow categories that our government will be legitimately allowed to prescribe or proscribe. So we spend a lot of time trying to figure out where that is. But that becomes part of our American culture and our democratic tradition. Because we've got a pretty far, that line is pretty far away in many regards. Okay? And for a long time, at least from a long time, since the 70s, that line with regard to a specific area of speech, which we're going to really focus on tonight, and that's campaign finance. Right? That line for a long time was pretty far out there. And now it's changed. Now the question that came up with the Citizens United case initially was whether there was an underlying federal law that turns out to may or may not have had an effect on some form of speech. Okay? So whenever I talk about the Citizens United case, I'm always drawn back to one of my favorite legal authors, and that's John Grisham. Okay. And his book and movie, The Pelican Brief. Has anybody seen that? Right. That's about, if you remember the intricacies of the plot, there were two Supreme Court justices were assassinated by some backroom billionaire who wanted to change public policy by altering the composition of the Supreme Court. So he figured if he could get rid of two justices, he'd get the majority that he wanted. So whenever I talk about Citizens United, I always sort of think that there are certain elements of this case that were manufactured because of the composition of the court. Okay? And when you actually read the case and you look at the mechanics of what went on here, and a case that was decided solely on partisan grounds, it sort of goes back to some of the John Grisham conspiracy theories. Okay? So again, the mechanics of the Supreme Court, all you need is 4 justices to agree to accept a case. It's not too difficult. They call it the rule of 4, and you only need 4 to get there. You need 5 for a majority. All right, there are 9 justices, you need 5 to agree on an issue, and it doesn't matter if you have 5 or if you've got whatever math you want to do. As long as you have a majority, you get a winning precedent. And scholars like to debate whether a 5-4 precedent is weaker than a 9-0 precedent. Well, I'm not gonna argue on that one today. Maybe that's a real constitutional scholar discussion. But all I know today is that we have a 5-4 majority in the Citizens United case. In a case that in some ways may have been manufactured by the entities that had a stake in the case. So let's backtrack a little more. All right, who is Citizens United? Okay. We don't know. I mean, we sort of know, but we're not entirely sure because Citizens United is a nonprofit corporation with a political bent. All right, it's a right-wing, and I don't want to get too partisan, it's a right-wing group that believes in smaller government and is sort of not in favor of campaign finance reform and whatever other right-wing issues are out there. But above and beyond all that, they had an objection with one particular candidate, Hillary Clinton. Okay? So in 2008, this nonprofit corporation, which incidentally had a budget of $12 million, not bad for a not-for-profit, could do a lot with $12 million. Okay? So this nonprofit corporation produced a film called Hillary the Movie. In a bit, we'll show the clip in a bit, and get a little idea what it's all about. Okay? So they produced a 90-minute feature-length anti-Hillary Clinton film. And you'll recognize some of the pundits and commentators who were interviewed. They produced the film, they want it released. I don't know where it was going to go. It didn't actually get a lot of theater play, so the next stop was going to be pay-per-view. Okay? And now this is where the litigation comes in, because somebody within the Citizens United organization realizes that, wait a second, we have the Bipartisan Campaign Reform Act, also known as McCain-Feingold Act, which has a section that limits campaign electioneering. That's what we're talking about, electioneering. And it's a pretty fluid definition for what electioneering is. Things that appear on TV, or cable, or satellite. Okay. Now, in some ways, we have to ask the question of whether a feature-length film, regardless of whether it's partisan or not, really constitutes campaign electioneering. Right? I never bought that, to be honest with you. I'm still torn on the actual decision to a certain extent, but I never thought of this film as a real campaign electioneering issue. Okay, maybe I'm naive when it comes to this, but I thought of this as a feature-length film, not necessarily a campaign advertisement, even though it was obviously aimed at dislodging Hillary Clinton. So there's a section of the Campaign Reform Act that doesn't allow this sort of material on TV or broadcast within 30 days of the election or 60 days of a primary or some nuance like that. This is a federal election campaign finance rule as administered by the FEC. All right. Here's the real rub. Citizens United sees this, and rather than wait around to get slapped on the wrist by the agency or the commission, Citizens United files an injunction. Right? They bring a declaratory action. For the lawyers in the room, they challenge this in district and federal district court to see if this law is even constitutional. Okay, you can do that. If there's a law out there, you can challenge its constitutionality and bring it up before a court. So again, when I say somewhat manufactured, this is what we have. We've got a manufactured dispute. The district court basically tells Citizens United, now we're going to side with the Federal Elections Commission, which the court does. Citizens United then ends up appealing, gets it appealed to the U.S. Supreme Court, which miraculously found 4 votes to take the case, and then miraculously found 5 votes to issue an opinion. Okay? So, you know, if there was a different majority on the court, perhaps this case wouldn't have even been granted cert. Perhaps this case wouldn't have even been brought in the first place. But, you know, the composition of the court is sometimes sort of a fluke of history, and you know, we're living in one of those periods right now. So we have this case go all the way up to the Supreme Court with questions about how far we're going to go with our government regulation with regard to campaign finance rules and how much we're going to rein in certain types of entities in funding campaigns. The 2 types of entities we're talking about here are corporations, right, and unions. One for the right, one for the left. One for the right, one for the left. Okay. So there are going to be some restrictions, but we're asking the question of how much can a corporation donate to a political campaign from their general treasury funds. Okay. And then it gets a little murkier because now we're dealing with a nonprofit organization, a nonprofit corporation that is outside the scope of a lot of the campaign finance rules, which my colleague is going to be talking about in a bit. So, you know, we're really talking about almost a bottomless pocket, right? The deepest of pockets being able to funnel money into political campaigns. So it's sort of controversial. And it's so controversial, the Supreme Court decision on this is 180 pages, which includes a 90-page dissenting opinion by Justice Stevens. And it's decided on strict partisan grounds, with Justice Kennedy writing the majority opinion, There were concurring opinions by Justice Roberts, Justice Alito, and Justice Thomas. But overall, it was the five conservatives against the 4 liberals. The 5 conservatives arguing that this was an unconstitutional restraint on speech. So I'd just like to quote Justice Kennedy briefly, and then I would like to show you the clip. So I apologize, I'll be going over my allotted time. Justice Kennedy wrote, "Speech is an essential mechanism of democracy for its means to hold officials accountable to the people." So he's talking about political speech. So in some ways they framed this as a political speech issue, which would then confer even greater First Amendment rights, which sort of changes our view on things. So with that, I would like to go over my time to show the trailer to the movie, just so you get an idea of what this controversy is all about. So whichever works.
Clean. That's why they don't want us to look at her record.
Well, I think it's worth remembering, after her healthcare fiasco, the Clinton team put us aside.
I mean, certainly you have to ask whether or not she's learned a lot from that experience. It was a failure. She knows it was a failure. It was a very embarrassing failure for her.
She's a person who's struggling herself with figuring out who she is, or more importantly, how she wants to present herself to the American public.
She's deceitful. She'll make up any story, lie about anything, as long as it serves her purpose of the moment. And the American people are going to catch on to it.
I can't think of any other politician in history who has shown such a disrespect and a contempt for the Constitution and the rule of law as Hillary. And I represented Richard Nixon's best friend, and I knew Richard Nixon. And I'll tell you something, she's no Richard Nixon, she's worse.
Ruthless, vindictive,
Venal, sneaky,
ideological, intolerant.
liar is a good one.
Scares the hell out of me.
I am sick and tired of people who say that if you debate and you disagree with this administration, somehow you're not patriotic, and we should stand up and say, we are Americans and we have a right to debate and disagree with any administration.
Okay, with that, I will leave it to you to decide whether that is
Senator Clinton is claiming
electioneering.
basically the entire 8 years of the Clinton presidency as her own, except for the stuff that didn't work out, in which case she says she has nothing to do with it.
She makes herself sound like she has diplomatic experience, like
So, yeah, I leave it to you to decide whether that is campaign electioneering, advertising, or pure speech that is good for our democracy. So with that, I defer to my colleagues on the panel. Thank you.
Could you bring the speaker output down to about 80%? Computer, thank you. Thank you, Roy. Is everybody able to hear me okay? In the far back of the room?
Yep.
Right. And I thank the League for putting on this forum. It's a very timely subject. It's timely any time of the year. We are in the middle of the, quote, next election cycle. As you probably are aware, the election actually is not going to occur until November 2016, but the campaign has already started. People are out there asking you for money currently. All right. Now, I have to make a small disclaimer. Some of you may know me as counsel to the local chapter of the ACLU. I am not speaking tonight on behalf of the ACLU. It really has not taken a position with respect to campaign finance reform. It does have an opinion on the Citizens United case. I'm not about to repeat that here. So I'm really speaking in my own behalf. Roy said that the Citizens United opinion, quote, may be manufactured. I'll be a little bit more direct. I would say it's outcome-driven. The majority knew where it wanted to be at the end of the decision. Anything that was in its way, it swept aside, including existing Supreme Court precedents. In my opinion, it's more than maybe, it is manufactured. Now, the holding, Roy didn't get quite there, but you've got to remember that Citizens United did not create a brand new system for campaign financing. Citizens United, its holding was that a not-for-profit corporation, you heard about that, Citizens United, may spend unlimited funds of its own within 30 days before an election on a communication opposed to a candidate. Now, subsequent decisions of lower courts have expanded on that holding, the logic of that holding, to apply it to unions, to other types of communications at other times, and also there's a case out of the district court, the Circuit Court of DC, which says that if third parties are able to spend money, then they are able to raise money of unlimited amounts. All right, so what's happened as a result of Citizens United? I know Sam has got some information on that. It's very, what we had in 2012, that's where I have my data, is, for example, in the House races of that year, $1.1 billion was spent on behalf or opposed to the candidates just for the House of that year. I have given to you, or laid out, or circulated this little poop sheet on where money may be raised, or how it may be raised, and how it may be spent, and how on disclosure of donors. This is the law following Citizens United. And this is really my task tonight, is try to tell you a little bit about the limits on contributions, the limits on expenditures and disclosure. This gets a little dry, so I'm not really going to go into great detail here. Besides the entities that were talked about in Citizens United, I've also added the individuals, and you can, by way of comparison, again, Citizens United did not change the law with respect to the amount that individuals or corporations can directly give to candidates or PACs, and it did not change the law on what individuals can spend out of their own pockets. So you think about Bill Gates and, let's say, Louise Slaughter and her re-election committee. If Bill Gates wants to donate $5,400 to Louise Slaughter's re-election campaign, he may do so. That was the law before, and that was the law after Citizens United. Now, if he also wants to go out and spend $500,000 out of his own pocket opposing or in support of Louise Slaughter, he may do so. That was the law after Citizens United, as the law before Citizens United. So one of the effects of Citizens United is maybe it sort of freed individuals from what was maybe sort of a limitation, a self-imposed limitation on expenditures. But you got to understand that Citizens United was not a total game changer in terms of campaign finance reform, if you call it reform. Other impacts of having this increasing money being raised is we have what we call a wealth primary. That is, if you're going to run for federal office, you need to have a network of donors or prospective donors. And if you don't have that network, or you're not a self-funder, you're going to exclude yourself. So you're not getting the same number or quality of candidates as a result of this increasing flood of money, people needing to have on hand a way to combat the outside money. You also have what I think is the, quote, corruption. Roy didn't really explain what the corruption was in the opinion of the court. The the corrupting influence of money, in the opinion of the court, was that the money would be given to a candidate in return for a vote on a bill, the quid pro quo. Absent such a quid pro quo or the appearance of such, then there was no real reason to limit expenditures or by individuals or by super PACs or not-for-profits. So, but the problem is that Congress people do not necessarily vote on a final bill based upon who gave them money. Studies show that. What people, they will vote principles, even though they may end up looking